My colleague DJB Mujapelo could not be here because of some other reasons. But however, since the Pretoria and the Johannesburg courts are under the leadership of one JP, I don't think that there are vast differences as to what is required from acting judges by the two courts. I must also just mention that I gained a lot from attending this presentation, and this also confirms the view that the judges always need to be trained, because without trainings or without attending workshops of this nature, we won't become better judges. Johan, thank you very much for the presentation. About 40% of the things that I'm going to talk about, you touched on them, and I'll just make some few additions to what you said. You mentioned something in passing which is very important. Make sure that you've paid your bond. and this is serious, guys, because it says one thing, that when you're on the bench, you're not going to sign your check as you used to, when you're an advocate or an attorney, and the money is not that good there. Sometimes when you sitting in a matter with two senior counsel, when they appear before you on the third day, you say, oh, this is the money that I'm going to work for the whole month. They just make it in 3 days. So you really need to make a serious introspection before you decide that you want to be a judge. I also want to thank the other speakers who were here. I was also impressed by what my colleague Linda said about when she spoke about the judicial ethics. That is a very important subject, and I'll also speak to my JP. I think I would be inviting you very soon to come and amplify what you've said, because it is indeed true. When you're going to act, you sit in the JP or the DJP's office, you take that oath, you are nervous, as Johannes stated. You don't even internalize exactly the contents of the oath that you are taking. You're just taking it as a formality. I remember one day I was addressing the advocates, and I asked a few of them, do you still remember the oath that you took when you were appointed as an advocate? Some of them could not even remember exactly what that oath entailed. But I think it's very important that we should revisit that oath that we took as advocates, and also us as judges, we need to look at the content of that oath again. You know, I'm comparing this to the people who are going to enter into a marriage. Before they say I do, they go to the pastor, who they go through some sessions with them. I personally think that even with judges or acting judges, there should be a mentor to sit down and discuss exactly what does this oath entail. I'm not going to give a judgment here, so my presentation will not be chronological. So you'll pardon me for that. But I want to emphasize that, especially in respect of the topic that I've been given to discuss with you, it's important for acting judges to know that they've got the same responsibilities like any other appointed judge. The judiciary itself is not something that is abstract. You as an individual judge, whatever you do has an impact on the reputation that the institution have. So you've got to be very careful when you sit on that bench, when you take that oath, as to exactly what is it that you are going to do. My colleague Chifundo has also stated in his closing remarks that whatever you do, you may close doors or open doors for us. for others. And what he said is very important to me, and especially to women judges and also to judges of other color, because there's an institution that was, allow me to use the word, operated by only white males. Now, when you are in the judiciary, let me say, as a woman, you do something wrong, you're going to tarnish the image, and the people will be saying, no, women don't deserve to be in this. So it's very important that when you are on the bench, you should know that you may close or open doors for other people. Now, the important question is, should a lower standard be expected from acting judges or not? Or when you are an acting judge, are you expected to execute your responsibilities like senior judges who have been on the bench for 15 years or so, or not? And when you look at the definition of an acting judge, it says an acting judge is a judge. So you are expected to execute your duties in a very responsible manner, because you are dealing with the lives of people. You are dealing with the status of people. And there are certain matters where you'd be expected to send people to imprisonment for life. There are instances where you've got to rule that there's some companies should be liquidated. So you've got to take your job very serious. I once had a discussion with my colleague Mujapelo, and we said, before advocates become members of the bar, they go through some training, they write exams, same as attorneys, they serve articles for about a year, they write exams. Now, if people want to come to the judiciary, why is it just so simple to come to the bench? Is it necessary that there should be some training for a certain period before one can be appointed as an acting judge or not? Well, these are some of the questions that we still need to discuss, especially having regard to the importance of the job that you are expected to do when you are on the bench. One of your colleagues, Susan, I don't see her here, she informed me that in other jurisdictions, people are specifically trained to be judges. You go to university for some years, and judges are appointed from those people who have gone to university for such a training. Is this something that should be introduced in our jurisdiction? I don't know. It's something that we need to discuss as we proceed having workshops of this nature. I must also just indicate that I would encourage you to have regular workshops. I'll keep on mentioning attorneys because I was an attorney before I was appointed as a judge. Attorneys, almost every year, they organize workshops for 3-4 days wherein judges are invited, and we tell them exactly what is it involved in being an acting judge. And after those workshops, about 70% of them will tell you that no, they don't think it's a good thing to go to the bench, because we try to be real. It's not just a question of status to be an acting judge or to make your CV look good that you've been an acting judge. I remember in 2004, before I was appointed as an acting judge, I was privileged to be among the group which were mentored by Johan. I hope you still remember those times, Johan. And from that group, about 90% of the people that he was mentoring are now on the bench, and it has been a valuable experience. It's unfortunate that what maybe the JP of the time wanted to introduce, that there needs to be a mentor to assist the newly appointed judges, did not work out. But my personal view, I still think we need such a person to assist acting judges, especially after hearing about what you are not told when you come to act. Johan, this is not the closed chapter. I'll still take it further with my JP, and also depending on what you'd be saying about this issue of having a mentor, because to be honest, we are very busy. Much as when you come there, we tell you that our doors are open, always come. With the workload that we have, we don't have enough time to assist you. A lot also was said about a handbook to be given to acting judges when they come. Fortunately, in Pretoria, we've got a booklet that we call Judges Etiquette. I think it consists of about 20 pages or so. We formed a committee in which senior judges were members of that committee, and a lot of contribution was made by retired Judge Southwood, wherein we deal specifically with these issues that were mentioned by Johan that you are not told about. So when you go to court, you should go in first. At the tea room, how should you behave? Those important things, we've tried to put them in a booklet. And in particular in Pretoria, what we have done about 2 years ago, we invited all the acting judges who are going to act for the very first time, that we should have a training of some sort with them for 2 days. It's important that before you go there, you need to know what to expect. When I acted for the first time, I sneaked to the court on a Sunday, went to the court in which I was going to appear, sat on the bench. I just wanted to have the feeling, and it's important. I remember one of my colleagues, well, I'll mention his name because he's not here, Judge Tsoka. He explained his experience when he was on the bench. You know, when you look at the bench, that other part that hides your books is very important. He said that in his first case, you know, he was really panicking. He was nervous. At one moment, he spilled the water that was in the glass. Fortunately, nobody saw that. But it's important, go into the court, sit there, have a good feeling of what is happening, rather than to think that on the first day you'd be able to cope with the pressures that you'd be facing. And that pressure, I must tell you, is not only with the acting judges. Some of the judges, if not all, we do feel that pressure. Usually on the first day of the term, on a Monday in the 9:15 tea room, I had one of my colleagues, when we were about to start, asking, tell me, when is the next recess again? So it's really demanding to be on that bench. As I've indicated to you that we should seriously ask ourselves as to whether should the standard of an acting judges be low or not, or should it be the same? And when you come there, you need to be ready for the task, as I've indicated. And the oath that you shall have taken, all that is set out in the oath must be a guideline to what you'd be doing as you'd be sitting on the bench. I think it's important that I should just explain to you exactly what you would be doing when you are invited to act. In Pretoria, on the civil trial roll, you'll all know that at the moment we've got about 150 to about 180 matters on the roll every day. Those are the matters set down for trial, and we've got only at most 10 judges to deal with those matters. It's very difficult to juggle with that role, so that at the end of the day, everybody should have an opportunity to be heard, or those matters that can be finalized during roll call, we try our best to finish them. But as an acting judge, if you see on the first week that you're on the civil trial roll, don't expect that you'd be getting that file 2 days or a week before. Pretoria and Joburg are not like Northwest or in the Cape, Northern Cape. You get your file about 9:45. You are expected to start with a trial at 10 o'clock. All you need to do, you should familiarize yourself with the pleadings in that about 15 to 20 minutes. You should look at that. That's why we put more emphasis now that the parties, they need to prepare proper pre-trial minutes, pre-trial conference minutes, because that is a document that would assist you as a judge to know exactly what the issues are, how many witnesses will be called, so that you can be able to deal with the matter effectively. When I allocate a 2-day matter to you, on the second day when you finish, don't expect that on the third day you'll have an opportunity to write a judgment. Another matter would be in your chambers. So you need to improve your skills of being decisive in whatever you do. You really need to be ready for the task. With the unopposed motions, you're having a minimum of 50 every day. Some people may think that being in the unopposed motion court, it's an easy court, those matters are not opposed, but as far as I'm concerned, it's one of the most difficult courts to run. Because with opposed, you've got a benefit of arguments from two counsel, and then you can decide which argument is more persuasive, and also just you as a judge to give good reasons for your judgment. But with unopposed, you really need to read all those files. You need to, and when I'm saying unopposed, I also just need to mention that there are opposed matters on that. You get opposed Rule 43s. You get opposed application for summary judgments. Sometimes in one day, you've got 4 opposed applications for summary judgments which are involved. And you need to be ready to deal with those matters. Those are not simple matters. Sometime last year, there was a matter wherein one of the acting judges reserved judgments for about 2 years. It was an application for summary judgment. I had to call him and say, but why did you reserve for so long? He says, no, I've written to the parties, requested them to give me heads. I said, no, they've argued, you can't expect them to give you heads again. And I said, just give me your prima facie view. Do you think this matter warrants to be heard in a trial court or not? And he said, yeah, yes, I think so. So then you should have given that ruling immediately after the argument. And I said, fortunately, that ruling that you've given is not appealable, but that does not mean that you should just grant leave to defend in all matters because those orders are not appealable. You've got to apply your mind to those matters. And with the unopposed motion court, you get those files a day. You've got a day to make preparations for those matters. With the opposed applications, in Pretoria, we set down 50 matters opposed to be dealt with by 4 judges. You get them on about 2 weeks before the hearing. And understand me, when I say 2 weeks before the hearing, this does not mean that in that 2 weeks you'll only be working on those applications. There's other matters that you'd be dealing with. And in Pretoria at the moment, is on very rare occasions that we allocate urgent applications to acting judges. But sometimes we are forced to also give acting judges to deal with the urgent applications. In a week, we deal with about between 50 and 80 matters. Well, of course, depending on who the judge would be. I know that when Judge Southwood was doing the urgent, there wouldn't be cases coming. So one of the elements or something that you need to do, especially when you are in the urgent court, is that on the first day, you must just be crazy. because most of the council, when they hear that you are dishing out orders, all other applications will be coming during the course of the week. As another colleague said to me, one of the requirements of a judge is that you've got to be insane. So you'll see the importance of that requirement when you are in the urgent court. We've got appeals. We're dealing with admissions. We're dealing with full court appeals. As Johannes stated, the other matters that we are now dealing with, they come in volumes, surrogacy matters. You've got to deal with those matters in chambers. Automatic reviews, petitions. Petitions are allocated to 2 judges. You get very big files that, in terms of the judges' etiquette that we've made, we expect you to deal with them within 48 hours. And sometimes it's difficult because you'd be having trials, civil trials, you'd be for your unopposed. And the other thing again that comes your way are the bail appeals. What I do, because I know that my colleagues have got a lot of work to deal with, most of these bail appeals, I dish them out to acting judges. So when you come there, you should expect to deal with such matters. And it's important that always, if there's something that you don't understand, just seek guidance from other colleagues. By giving you this background, I'm really not trying to intimidate you, but that is what you should expect when you come and act in Pretoria or Joburg. For those of you who want to come and act, this is the time to start preparing yourself for that moment. You don't need to wait until you get a call or you get a letter from the office of the JP inviting you to come and act. I must tell you, for those who don't know, sometimes I do receive objections from litigants, from attorneys, saying that we've heard that so-and-so is going to come and act. We are objecting because of this and that. So whatever you do as counsel, you've got to be very careful, because we do get those objections from the litigants. We are forced to give you an opportunity to respond to that, and you must know that we don't have ample time to deal with that, but it's important for you to know that there are objections that we receive from the attorneys regarding the appointments. I also know of one acting judge. She acted only once because she was giving the unopposed motion court. She dealt with a Rule 43 application for 3 hours. Counsel rushed to the DJP's office. It was Judge Stafford by then, and then they said, no, we don't want this person anymore here. She cannot deal with a matter involving the interests of the children. And their concerns were legitimate. Unfortunately, she never came back because I think she was not ready, because especially with opposed Rule 43 applications, you need to learn the tricks, the techniques of how to deal with it. Maybe the first technique, you should know that it's not appealable. So don't go and spend much time looking at such applications. But you need to apply your mind to such applications. The other thing that as an acting judge you need to know is that when you must familiarize yourself with the environment. As they've said, you should know where to park. When you arrive at the chambers, my recommendation is that the judges who are on your floor, introduce yourself to those judges. We don't expect that you can go to about 30 or 40 judges and introduce yourself when you start. What we do is that during the 11:15 tea, myself or the JP will introduce all the acting judges. But I'd also recommend to you that much as you'd be introduced in the tea room, try to make some time, come in the morning, because I take most of the oaths, but go to the office of the JP, introduce yourself. Sometimes it's embarrassing, and the JP likes doing it. He finds you in the tea room and say who you are. And, and if you can do that on the first day before you start going to the bench, that would be a plus to you. Start on a wrong footing. Also, as to how you address other judges, I think Johannes put it very well. Be very careful. I think it's better just to address other judges as Judge so and so, and then maybe those judges will tell, no, just address me on first name basis. But just don't be too quick to start addressing judges on their first name basis. Sit back, listen, see what is happening, and then when you are used to it, it is then that you can decide what step you are going to take. Fortunately in Pretoria, there are no special seats reserved for the JP or the judges. You can sit anywhere. There are those who have acted there. I think the atmosphere there is collegial. Also, in the judges' etiquette that we've got, it's important that you familiarize yourself with the contents thereof. It mentions things like a cell phone in the tea room is a no-no. Make sure that you've got your jacket when you go to the tea room. And Johannes spoken about also the topic that you are going to raise. Be very careful about the comments that you are making when you are involved in topics. When we drafted our judges' etiquette, I remember the senior judge therein said in the tea room, you should not discuss anything that is not law-related. We just felt that that is too strict. But I'm just mentioning this to show that, there are certain things that you need to understand when you go to the bench, that it's a lonely place. There are a lot of rules. It's not as free or as independent as you would have experienced when you are in your chambers as an advocate. And another important thing is they've emphasized it, that it's important to try and finish all your judgments while you are still busy with your acting stint. Because if you're not going to do it, you won't get time to deal with those judgments when you are in your practice. And again, don't expect that you would be paid for the hours that you would be spending writing in your chambers. Surely most of you, there was once an article in the newspaper years ago, one acting judge wanted to claim for the hours that she spent, and she was never invited to come and act again. But the question of, before you come to act, having enough reserves or money in your account is very important, because after acting, you go back, you must now deal with the judgment. That is going to take the time of your practice, and it may also affect your income. And after acting again, it's not the end of the story. Don't think that, no, I've given all the judgments, now I can go and enjoy my freedom again. That is not the end. You'd be hit with applications for leave to appeal. And you must come back. Deal with those matters. Deal with them objectively. You should understand that when one applies for leave to appeal, they don't mean that you don't understand the law. If there are reasonable prospects, grant that leave to appeal. But you are not going to get a cent for sacrificing your time, coming back to deal with that application, because again, before you deal with that application, we'd expected to read your judgment, to read the notice itself. My colleagues, when I came here, some of them informed me that they would recommend that when you come, as the JPS indicated, that if you want to come and act for 1 week, it's not advisable. At least now, maybe in future, would allowing advocates to come and act if they can give us almost a month. Because we believe that in that month, you get to have a good feeling of what is it to be a judge. You've got to get an opportunity of getting those automatic reviews, getting those bail appeals. And when you decide whether you want to come to the bench or not, you know exactly what is happening in that side of the law. Another important aspect that I think you should be alive to, it's a question of marking your judgments whether reportable or not. I must state that especially if you look at the law report, you know, previously it used to be a joy to take a law report, you go through the cases, you'd find new points of law, but this nowadays, about 60% of the cases, they really mean nothing. They just reiterate the law as it stands. And you ask yourself as to why were these cases put in the law report. And mainly is because, especially most of the acting judges, they like marking their judgments reportable. Last week, I was signing a judgment of another acting judge. It was an application for leave to appeal, a 2-page judgment. It's marked reportable. So if you did not mark your case reportable, that does not mean it won't be reported. We do get letters from advocates sometimes saying, no, this is a very important case. Can it be reported? And when we look at it, we see that no, indeed there are some important issues in that case. It will definitely be reported. I had a meeting with guys from Judicial, asking them as to why is the quality of the law reports not so good. And they mentioned that there are, I think, about only 3 people who must go through all these cases that are marked reportable. So you can see that with that workload, they don't apply their mind. Maybe they're also in business, mind you. They'll just take maybe the first few cases marked reportable, put them there. But I don't think it will be in the interest of everybody, of anybody, that we should have such cases in the law report. Especially, let me go back and touch on the applications for leave to appeal. I had one colleague saying that when he's doing an application for leave to appeal, what he does is that if he reads his judgment and finds that it's not that good, he does not grant leave. But if it's a good judgment, he grants leave so that the senior judges can see that he can write well. So somehow, these are the new tests now that, that are created by some of the judges. In concluding what I need to do, I want to emphasize that always see to it that you seek advice from the senior colleagues. Because you cannot know everything. This has been said. And much as there is a workload, please don't hesitate to adjourn your court, go to the nearest colleague and ask exactly what is it that should be done with the matter in question. Thank you.